Next up is Notary Law and Ethics, and with over 25 years as a commissioned notary himself, I think you will be in good hands with Mr. Michael Closen.
Thank you. And thank you for being here. This is astonishing. This is the largest. I've been doing programs around the United States for many years. This is the largest state-sponsored notary event that I'm aware of in 25 years that I've been doing this. So yes, good for Texas. I'm here with some bad news and some good news. The bad news first. A good deal of what I do in the notary arena, and I'm a retired lawyer, please don't hold that against me, but I was an attorney and a law school professor, and so one thing that I've been doing for many years is that I serve as a consultant on legal cases. Lawsuits, I go and testify in court cases, and over the last 6 months, something odd has happened. I've had 3 calls from 3 different states about notary cases, all for millions of dollars in claims. I've had 3 cases, 3 states, where the lowest amount being claimed against a notary and the notary's employer was $3 million. And the highest of the 3 claims was around $10 or $12 million that was being claimed. Now, you know that sometimes lawyers just put in big numbers. In the cases they file, they just pick a number. In these cases, those numbers could be documented. The claims against the notaries and the employers in those cases were factually arguable to be $3 to $10 or $12 million. So, for some reason, I've been hit with a batch of cases, very serious cases against notaries and their employers. It can happen. It's unusual for a claim to be that high, but it's happened lots of times in the 25 years that I've been doing this. It's just that there seems to have been a batch of these. The most important thing is that the good news is that during the course of this hour, I'm going to give you 4 or 5 tips about conducting your notary practice that will keep you out of lawsuits. 99% sure, if you do 3 or 4 of the things that I'm going to mention in the course of this hour, you will never, ever be the subject of a lawsuit. I can almost guarantee it that much, and I'm serious. So we're going to get started. I'm going to give you some practical tips about what to do, how to conduct your services so that you'll stay out of legal trouble. I was asked when I came down this year, and I had the good fortune of being here a couple of years ago for the first of these Texas programs, but they said, come back down and do notary law and ethics. Well, notary law and ethics, if you tried to cover that, would take many hours. I taught law school courses 30+ hours, 30 hours of law school coursework on notary law and ethics, and that wasn't enough. So an hour isn't enough to do everything, but I can help you on 2 big topics. So I picked 2 of the most commonly inquired about subjects. One is about notary liability and how to avoid liability, the use of reasonable care. So I'm going to spend about half of my time talking about that very important subject. The other one that gets a lot of attention is that a lot of notaries are concerned about avoiding the unauthorized practice of law. Since what we do as notaries is so closely connected with a lot of legal documents and legal transactions, a lot of notaries worry that they might be crossing over the line sometime and get involved with the unauthorized practice of law, since most of you are probably not lawyers as well. And that's a serious concern. because the unauthorized practice of law in Texas and every other state is illegal. It's criminal. It can get you, at least, it can cause you to have your commission revoked by the Secretary of State. So, but it's not a very common problem at all. I don't want you to worry too much about it, and I'll tell you the key things to know. As we get into this outline, if you saw it, in my outline, and I'm not going to talk about all these details as I'm speaking to you today, but in the outline itself, I wanted you to have the specific citations to the places that you can go to confirm the things I'm saying. So I have cited in my outline to the Texas law, to the Texas statutes, and the Texas administrative rules, which are the regulations. So you'll find those sites. I've cited you to the American Society of Notaries book on Texas and the National Notary Association book on Texas. You see those at the bottom of that list. And then in the middle, there are two of the leading treatises that have been done in fairly recent years. Van Alstyne did a wonderful notary public encyclopedia that he published in 2001, and then, forgive me for the boast, but I did the 2018 book, Notary Best Practices, and it's all about things to do, best practices to follow in order to avoid liability and ethical concerns. So forgive me for that reference, but it's in the outline so that you can have a look at it. First topic then, let's talk about notary liability issues, and for you the most important part of that, how to stay out of trouble, and that's why I'm here to help you with that. But to begin with, skip with me to the next part of this. Let's go to point 4. I'm going to go back to that previous slide, but in point 4, I make the point that I'm going to be talking about negligence, malpractice, notary malpractice. Of course, it stands to reason that if a notary does something intentionally wrong, if a notary commits fraud, if a notary steals money from a notary client, something like that, if a notary engages in intentional wrongdoing, of course, that's unlawful, it's a crime, but that's easy. None of you are here and going to engage in that kind of activity, we hope. Some notaries do go astray, and they do commit intentionally unlawful, they do engage in intentionally unlawful activity, but I want to talk about the more common issue, and that is negligence liability. So back to the start, that's what I'm focusing on. A notary is going to have full personal liability. And I want to emphasize that, but not to scare you, all right? Full personal liability means that if you do something that qualifies in the list I'm about to read with you, if you do something wrong, the plaintiff coming after you in a lawsuit could get your house, your car, your bank accounts, your boat, your savings, everything is available. You have full personal liability if you do the things that are going to be on this list now. But remember, I'm going to tell you how to avoid getting in trouble. You'll have full personal liability if a faulty notarization or other fault in performing an official function occurs. If you make a mistake, a serious material kind of mistake, in doing a document notarization, you get the certificate incorrect, you leave some things out, or you have incorrect information, something of that sort. Or it says another kind of fault in performing your notarizations. Let's say that you allow your seal to be stolen by somebody, and that person goes out and forges some notarizations and causes injury to somebody else. The fact that you negligently allowed your seal to be stolen is a situation in which you'll have liability. Or you don't protect the privacy of your document signers. You allow your journal to be readily stolen or taken away by somebody else who then divulges some personal information. Somebody's injured by that breach of confidentiality. So you'll have liability if the notarization you do is faulty, or if something else in your official service is faulty and causes financial injury is number 2. We're talking here about a situation where a faulty notarization or other faulty performance actually harms somebody by injuring them financially. We're not talking about personal injuries and so on. So just because you get it wrong, we're all human here, we all make an occasional mistake, just because you have an error in a notarial certificate doesn't mean somebody's hurt by it. Most of the time, an error isn't going to be that severe, and especially no one's going to be injured. So just because you make a mistake doesn't mean you have legal liability. It has to result in financial injury also. The third point is about who this is who gets hurt by your faulty notarization or faulty notarial service. It can be anybody. It could be the document signer. It could be a third party who relies on that document. It could be a third party who's affected by the faulty notarization, or maybe it's a forged notarization. So in order for you to have personal liability, there's got to be a material kind of error or omission that has occurred. It's got to cause somebody financial injury, and that person would typically be document signer, somebody relying on it, or somebody affected by the notarization. If that happens, as point 4 says to you, then the notary's been guilty of negligence. Negligence. It's not intentional, but it happens if you're cavalier and unconcerned about your duties, something goes wrong, hurts someone, and all of that. So the focus here is about negligence. Now the good rule, the important good news, is point B. The other side of the coin of negligence, if you think about a coin, and on one side of the coin is negligence, on the other side of the coin is reasonable care. Reasonable care is the notary's protection against liability for negligence, or what we call notary malpractice. Right? If you engage in reasonable care, you will not be negligent and will not be liable. Right? We all want to engage in reasonable care. Now, a couple of comments about reasonable care. That first one there. If we didn't have reasonable care as the standard for what we notaries have to do, it would mean the law requires us to be perfect, right? The law doesn't require people to be perfect. We can't be perfect. So if we had some other legal standard, if we were held absolutely liable all the time, if something went wrong and somebody gets financially hurt, that would mean we all have to perform with perfection. The law doesn't require that. The law has a lesser standard. As long as we use reasonable care, we won't have liability. Now, what is reasonable care, as point 2 says to you? Reasonable care is due diligence. It's carefulness, it's caution, it's prudence. And importantly, it's documenting that you've been cautious and prudent and used ordinary care in your performance. And I'll be emphasizing that to you as we go along here. So therefore, point 3, let's read this. Even if the notary performs a faulty notarial act that does indeed cause injury to someone, here's the good news, the notary will not be liable if the notary has exercised reasonable care. As an example, let's say that somebody comes in for a notarization and it's an imposter. You've got some wrongdoer attempting to use you to get a document notarized so that they can use it for financial gain for themselves. You're faced with an imposter. But it's a good imposter, a really skillful imposter. And you do everything that you're supposed to do. You make sure that they're present. You look at the identification, you look at it carefully, compare the picture to the person, the signature, you watch the signature on the document, you get it in your journal. You are a good, solid notary. If it turns out, after using all that caution and prudence, if it turns out, nevertheless, you notarize because this is a good imposter with a good story and good forged ID, you will not have liability for performing a notarization for someone who is an imposter and when somebody gets hurt by it. So this is wonderful news, right? If we just use reasonable care, we're going to be protected against legal liability. Here comes the important part of this now, in my opinion. The best practice steps that demonstrate and document that you've used reasonable care. What are those best practice steps? There are several of them here, so let's get started with them. The first one, pretty obviously, know and abide by your statutes and regulations. You take your business seriously if you know the statutes and regulations, and if you keep a copy. If you're like me, I have a copy of the statutes with me, next to me on my desk every time I do a notarization. So if I forget something, because I don't have the best memory, I can look at the statute or regulation right then and confirm what I'm doing. You obtain a bond and maybe liability insurance. In Texas, you're required to have a $10,000 bond, but Kathleen has already explained to you earlier what that means. That $10,000 doesn't protect you at all. It protects the public. If your bond company pays out, you have to repay the bond company. So, depending on the kind of notary services you perform, if you're performing the kinds of services for people engaging in business transactions of some value, if you're dealing with strangers and other people at times, and I've got a list coming up, a checklist for the high-risk notarizations that I'll get to. But depending on the kind of notary service in which you engage, you may want to consider liability insurance, errors and omissions insurance, or we call it malpractice, notary malpractice insurance. You can buy it for very reasonable rates for fairly substantial sums. So think about it at least, whether to have more than just a bond. Now you need to know and follow the procedures for notarizations. Do it by the book. Kathleen had a list that she went through. I am not going to repeat all the provisions that she has already covered, except for one or two. The first one there, toward the top of that screen, Kathleen mentioned this, but I want to emphasize it. It's so important. The notarial ceremony is a lengthy process when you think about it. From start to finish, when someone comes in and says, hello there, I'd like to have a notarization performed. From that moment on, you should be in red flag mode. You should be thinking about the whole process that you're going to go through, and if at any time before the end of the ceremony, before you shake the hand of the signer and he or she leaves, if at any time before that, if you detect that something's wrong, you stop that notarization, you refuse it right then. If you detect that a fraud may be going on, for example. So it's a ceremony-long process while you're evaluating the document signer. Does he or she appear to be competent? Are they willing to perform the notarization? Do they seem to be who they claim to be? All of those things are in your mind throughout the process. Kathleen talked about fees. She talked about identifying the document signer, perusing the document. Observe the signing. I wanted to mention that for a moment. The reason that we have always asked the signer to appear in our presence or be in our physical presence, as both Susie and Kathleen have said, so that we could touch them, but we're not going to. Part of the reason for that is so that we can observe when they sign the document or acknowledge it, and when they sign our journal entry, so that we can see how they do it. I stumbled there because I'm going to jump ahead for a minute. Pardon me, we're going ahead to a point. With all due respect to my friends here in Texas, in the legislature, and in the Secretary of State's office, in my not so humble opinion, the single most important bit of information to get into your notary journal is the signature of the principal, the signature of the document signer. Even though it's not required in Texas, Texas doesn't forbid you to get it. You be sure to always, always, always get the signature of the document signer in the journal entry. Why? Because that proves that they were there, right? Their signature proves that they attended the signing. And if it's an acknowledgement situation, in that unusual case where a document is allowed to be pre-signed, remember Kathleen talking about that? The one kind of notarial act where the signer can pre-sign the document, they don't have to do it in your presence. If they bring in one of those, the journal is the only place where you would get a present signature. I always want my document signers to sign at least once in front of me. And if they're coming in with some other kind of notarization, like an affidavit or a jurat, they're going to sign it in my presence, and they're going to sign the journal in my presence. And why is that important to me? I want to see how they do it. Is it going to be an easy, flowing signature done routinely like somebody does? Or is it going to be stilted? Stilted the way somebody might do it if he or she were trying to remember how they were to forge that signature of somebody else? Or is the hand going to be trembling from nervousness, perhaps, because this is an imposter who might not be that really good imposter who I hypothesized earlier? I want to see it done. I want to see how it's done, and then I'm going to compare it, a present signature, with the signature on the document that's being notarized and the signature that is on the ID. So I end up with 3 signatures to compare if I get a signature in the journal. If I don't get it in the journal, I have fewer signatures to compare. So I insist upon getting a signature. Well, in my state, it's required. Or it's not required. We don't even require the journal in. I forget which state I'm from. No, I've been a notary in a couple of states, and I do so much of this. Get a signature in the journal. It's permissible to do that. You'll find that it's very important proof. Be sure the journal is complete. That's what distracted me there. Proofread the certificate and the journal entry. Before you conclude a notarization, proofread. Proofread everything that you have written. If you've written an itemized receipt for fees, proofread it. Make sure you got it right. Proofread the certificate that you filled out and signed and sealed, and make sure you've got it right. Proofread your journal entry to make sure that you filled in everything that you wanted to and that you should have. Proofreading will prevent 98% of notarial mistakes. It's that important. In my book, I must recommend proofreading at least 100 times, no lie. This is a 500-page book. I probably mentioned proofreading that many times. I got called a couple of years ago on a case of a construction company president who had gone to his local bank to get the bid forms notarized for a project that the construction company was going to bid upon, right? It was a sealed bidding situation. So there were 7 documents that he had to sign and that had to be notarized, and then he sent it in to win this project. He went in, visited with the notary, they did the notarizations. This was a very good notary, and she got 6 of the 7 notarizations perfectly, absolutely perfect. But on the 7th one, she forgot to put her seal on the 7th one. Everything else was about it was perfect, but she didn't seal it. and she didn't proofread. So he took the forms, sent them in, and sure enough, his company was the lowest bidder. They were going to get that contract, and they were going to make more than $100,000 in profit on this construction project. Except that when the bids were open, one of the government agents looking at this saw that there was no seal on one document. His bid was refused. Of course, since the bid was refused, his company lost the project, so his company sued the notary and the bank because of the faulty notarization. My point is, if that notary had taken the time to proofread, go back and look at what you've done and make sure it's complete and correct, right? Because if you do it at the ceremony, there's still time to correct it before you conclude the ceremony. This would not have happened if the notary had proofread. I swear to you, in the many cases I've done over the years, in my work as a consultant and testifying expert, if the notaries had just proofread, at least 90% or more of the cases would never have happened if they had proofread. So it's an important, important function. Did I just... Yes, okay. Let me mention one other thing on the list. I may have just, not personally known. No, I need to go back. I'm trying to find, I skipped over one here. Give me a moment. It's the 3rd one on that list. Again, Kathleen talked about all these steps for the most part. You should be assessing the mental competence and willingness of the document signer. Those are important things to judge whether the signer is competent and willing. I want to mention the next one, administering the oral oath or affirmation. As Kathleen said to you, most notarizations do not require oaths or affirmations. Most of them don't. They're acknowledgments. Acknowledgments are the most common type of notarization that's used across the country. They don't require oaths or affirmations. The ones that require an oath, and this is easy, you always know because you look at the certificate, and if it says subscribed and sworn to, all right? If it refers to the document signer subscribing and there being a swearing, if that language, subscribed and sworn to, is in the document, that requires an oath or affirmation. It's what we call a jurat. It's always the language on an affidavit. Anytime you see an affidavit form, you're going to have a jurat. You need an oath or affirmation. This is not to be taken lightly. I'm not going to ask for a show of hands to embarrass anybody. But if you are not giving those oral oaths, I am here to tell you that when subscribed or sworn to is on the document, if you're not giving the oral oath, that notarization is almost certainly invalid. You have just committed an unlawful notarial act in doing a notarization without administering the oath or affirmation. This is important. This is important because the oath or affirmation makes that a very special notarization. This isn't just an ordinary document that's being signed and stamped and notarized. This is a special document where the signer is pledging on oath or affirmation subject to the law of perjury, right? If they lie in that document, they are committing perjury. That's how special this becomes. So this adds a layer of security and integrity to a document, and if you don't administer the oath or affirmation, that protection is lost. If you don't administer the oath, if the signer lied in the document, he or she cannot be prosecuted for perjury. We've lost that protection. If you haven't administered the oath, you have committed a crime in all likelihood. In virtually every state in the United States, it is official misconduct, a criminal act, for a notary not to do what they're required to do. I've had a case on many of these situations, and sure enough, I did one in the last year or so in Florida on this very situation. The owner of a company often came before one of his employees. He had a couple of employees who were notaries. He would bring documents to them all the time for notarization, and they got way too casual about it. They started taking this for granted. The boss would come in, he'd drop a document that he had already signed on their desk, and they would notarize the boss's signature. And a lot of those documents said subscribed and sworn to. Well, he dropped the documents they notarized. They didn't give him an oath, right? Sure enough, the boss was a bad guy at times. The boss lied big time in one of those documents. As a matter of fact, two of them. There were two pieces of paper, two different notaries, by the way, two different employees at the same company had not required the boss to be present, sign in their presence, and did not administer an oath to the boss. The local government discovered this, and the boss was prosecuted for perjury. The prosecutors, of course, went to the notaries to talk to them, and the notaries came clean. They admitted that they had not administered oaths to the boss. That let the boss off the hook. The boss could not be prosecuted for perjury. But the notaries were in trouble now, right? The notaries were in trouble because of this very uncomfortable situation. They themselves had committed illegal acts, official misconduct. They had notarized without putting the boss under oath. Well, in order to get their testimony, the prosecutor granted them immunity. It ended up they at least didn't get prosecuted, but they lost their notary commissions. This is a serious matter. If you don't administer the oral oath or affirmation, that notarization is invalid, and the oath or affirmation itself will not result in a perjury charge if there's lying within the document. So take that one especially seriously. We've already talked about observing the signing, being sure that the journal is complete, the certificate you're going to proofread now. Preserve and protect the notary seal and journal. Kathleen talked about that. I think Susie even referred to it as well. It's important to protect the seal and journal because if you're neglectful, if you allow one or both of those to be stolen at some point, there could be breaches of confidentiality and privacy for which you could be liable. Look at point 4 with me. I get myself in trouble sometimes. I get myself in trouble a lot of times, but one of the times that I get myself in trouble with some notary officials and notary educators is when I do this point 4 kind of stuff. Of course, we should take every notarization seriously, right? Every notarization should be taken seriously. But let's be realistic. Some notarizations are just more important than others, right? If you're notarizing a slip from the middle school so that Susie or Johnny can go on that field trip, that's important. Take it seriously, but it's not as important, to me at least, as some big real estate commercial transaction, some transfer of marital assets. Some other documents that we deal with are far more important. So what I say to notaries is, be careful with everything, but be especially careful, be savvy, as point 4 says. Be savvy and aware of what I call high risk, or at least higher risk, notarial settings. What do you look for? What causes the hair on the back of your neck to go up? What gives you that little shiver, that red flag that causes you to suddenly become even more alert? These are the kinds of things that should do it. When you don't know the principal, you don't know the document signer. This is not to say we should not restrict ourselves to notarizing only for people we personally know. But as soon as a stranger comes in front of me, I'm more aware than if my neighbor had come before me in terms of identifying and making sure this isn't an imposter. So when we are notarizing for people we don't personally know, we need to be especially careful. The second one, if the principal is in a hurry, office hours are until 5 o'clock and 5 or 10 minutes till 5, in runs this person wanting that notarization and it needs to be in a hurry. Or there's some excuse why this needs to be done quickly when the document signer appears. And especially if they're urging you to take shortcuts. Oh, you don't need to see my ID. Oh, you don't need to peruse that document. Oh, hurry up, hurry up. That's when I slow down, by the way. No, I'm serious about this. If somebody came in late in the day, I'm going to stay past 5. If somebody wants me to hurry, I'm slowing down. That is going to be the longest notarization I've done in recent memory because that causes me great concern. And it's probably going to be somebody I don't know also. So now we've got 2 strikes on the list. Multiple documents. If the principal presents multiple documents, a lot of people present multiple documents. I don't want you to get concerned about every one of these. I'm including here multiple documents presented over a period of time. I fairly recently did a case from New England where over a course of a few months, a lady brought in 7 documents to this very same bank notary, always the same notary, to have those documents notarized. It turned out the wife was the significantly younger wife of a significantly elder gentleman who were the wealthiest people in the county. And there's nothing wrong in my book with age differences there. I'm emphasizing there was a big difference in this case. They were multi-millionaires with a prenuptial agreement that limited the amount. He was literally 99, and she was 20 to 30 years younger. He was nearing death, and they had a prenuptial where she could only get only $1 million from his estate, and he was worth many millions. These 7 documents that were notarized over a period of a few months by the very same notary transferred his entire estate to her. His entire estate was transferred to her by the documents. And there were big-time problems, by the way. There were mistakes in every notarization. The notary didn't keep a journal. The story would take too long for me to tell you the tale of things that were wrong in this case. Multiple documents is one thing to look for. If they are of a high financial value. Now, I know we can't tell just from the name of a document. We can't usually tell whether it's of high value or not. But there are plenty of times when we know the document is of no big financial value, so we can put those aside. Sometimes the document signer will mention what's going on. Sometimes you will get an inkling of this, but if you get some impression that you have a document that's worth a lot of money, that's one to perk up about and be more careful with than Johnny and Susie's permission slip. This is the big one. If the principal is quite elderly, ill, nursing home, hospitalized, hospice patient, those individuals, of course, have full rights to have notarizations. We want to provide notarial services to every citizen. They have a right to a notarization if the other requirements for notarization are satisfied. But when you have a signer, a principal who's in that category, you need to be cautious about what's going on. I would say that in the numerous cases on which I've been consulted, that at least 75, 80% or more have involved people who are elderly, ill, hospitalized, in hospice, and often multiples of those. Very elderly, very ill, in a hospice, on his or her deathbed has happened to me a number of times. So be careful. And the last one is pretty obvious too. If somebody happens to accompany the principal, it's not just the signer, there are a couple of people there, and what do you know? The other person is going to benefit from the transaction. The other person is the beneficiary under the document, right? When you get one of those, that antenna better go straight up, and you're wondering if there could be some problem here. And of course, the way to handle that is to make sure that during a portion of the notarial ceremony, you excuse that other person. Get them out of the room. And while they're out of the room, you make sure that the signer is competent. You make sure that the signer is acting of his or her own free will. You make sure as you can, that the individual who is there attending the ceremony isn't there putting pressure on the document signer to sign that document. Get them out of the room, and of course, with everything that I've talked about, all these tips, put that in your journal. If you do remove somebody, and if you have any witness, if any witness or observer comes along with the signer, you always mention that in your journal entry. I ask them to sign my journal as well, so that I've got their signature to further prove this. But get that party out of the room for the time, ask some questions to make sure that nothing improper is going on. Journalize. Journalize. If you leave, if I leave you today with having impressed upon you just one point from this whole hour or so, that point would be the journal is your best friend ever. As a notary, the journal is your most important tool, your best friend, for a host of reasons. And I know others have talked about this, but I'm going to tell you a couple of the reasons that we're all right. Susie and Kathleen and I, and probably others yet today, are right. Besides the fact, by the way, I better say this, you're required to keep it anyway in Texas, right? You've got a statute and a regulation on this. Because I don't want to lose my place, I'm going to go ahead and cover this, and then I'll come to the most important thing I want to tell you. Earlier, Kathleen asked for a show of hands. How many of you have refused a notarization at some point? You've been able to say, I'm sorry, I cannot do that for you? All of you have won the Notary Lottery. You have done something that all of us should hope is going to happen to us someday, especially if all of you with your hands in the air put that in your journal. Here's what I'm getting to. If you were to be sued, or if you had to go before a disciplinary committee to justify what you had done as a notary, you know, that's what they do. The Secretary of State calls you in and says, hey, you've committed these faults. It's one thing for you to go before a judge, a jury, a hearing officer, and for you to say, oh, Your Honor, I acted reasonably. I'm the most careful, prudent person in the world. I always do it by the book. I'm really good at what I do. What good is that? Everybody's going to say that. We're all biased in our own favor, right? What you want is a written record. You want a paper trail proving that you are prudent and diligent and reasonable. And one of the best ways to do that, because other people in the world think that what we do is trivial. They think it's routine. Stamp and sign, right? Your friends, your neighbors, your spouses, partners, whatever, they all think, oh, anybody could do that. Just stamp and sign, right? That suggests that we do it always for everybody under any circumstances. We always notarize. If you want to really show that you're diligent, you'll have a refusal to notarize in your book. By the way, a refusal to notarize is an official act, isn't it? Right? As a notary, I say, I cannot notarize for you. That is an official act. That ought to go in my book. That ought to go in the journal. In the way the Texas statute and regulations are written, it appears to say that you have to journalize notarizations as if they're talking about when you do notarize, but you're not prohibited from journalizing a refusal, so get that in your journal so that if somebody says, oh, he or she always notarizes, you can say, no, I'm diligent, look there on page 14. I refused one when I shouldn't have done it. I testified in California a couple of years ago in a $1 million plus notary case. And the notary in that case had been a notary for quite a few years. Now that I'm thinking about this example, I'm going to use this for two purposes. I'm going to tell you the other most important reason to journalize. I always jump around. I'm jumping to a point that we'll get to later, and I'll just say, oh, we did that already. Anyway, this notary in California was a longtime notary. She had been notarizing for 4, 5, 6 years. She was diligent. She filled out a journal entry for every notarization. She had done 12 to 1,500 notarizations. And they were all in her journals, and by then she had done 4 or 5 books full of journals. You know those journal books are pretty small. She had 4 or 5 of them. Well, she got sued with somebody claiming that she was negligent and fraudulent. They claimed that she also did something intentionally wrong. She got sued. When we went to trial, of course, she's going to say, oh, I was diligent and all that, but who's necessarily going to believe that? But, of course, she had the journals to prove it. So the judge accepted the journals into evidence. The jury got to take the journals with them into the jury room, and I came along and I testified in her case, in this case, in her favor. Sometimes I testify against notaries if they deserve it. If they deserve to have support, I testify on their behalf. In this case, I was testifying on her behalf. And I testified not just about that one journal entry about the lawsuit. I got to testify about her 12 to 1,500 notarizations because I had looked at every single one of them. And she benefited from two things there. The first is that she had refused a couple of notarizations and they were in her journal. I got to say to the journal, this is a diligent notary. Look at that journal. Every line is filled in. She didn't leave anything out. And she had refused a couple of notarizations. She wasn't a notary who just pro forma stamped everything. And the most important thing about that example, and it's coming up in the next slide or two here, when you keep a journal, you're not keeping it just for one complaint, one lawsuit, one problem, one time. You are building a record of your performance as a reasonable and prudent notary. You are building a record, and the whole record goes to the disciplinary hearing officer or the judge or the jury, whatever it might be. They get to see this whole written volume showing how good you are, how devoted you are to what you do. That's the main reason that the journal is so important. In case you get sued, in case you're brought before a notary discipline agency. Now, as a footnote to that, of course, the other big reason that you want to do it is that if you're as forgetful as I am, the journal is going to help you remember the notarization that's being questioned, right? I can't remember yesterday already. If you're like me, you don't remember those kinds of details. And the other thing is that these notarizations, when we do them, are all routine. They're easy, right? We wouldn't have done them unless everything went smoothly. Who's going to remember the smoothly ones, right? Especially when we do a lot of them. So the journal is terribly important for those two reasons. It builds a paper trail of the many times when you've been so good, and the jury and judge are going to think, wow, if that notary is good all those times, they're probably good this time, right? They probably used reasonable care this time. And it's going to help us remember what we've done. So journalize all the time. Proofread. I knew I wanted to get to one more point. Proofread. Proofread the journal entry at the end, right? Make sure it's complete before the document signer leaves so that you'll have an opportunity to correct anything that happens to be missing. I need to go back to one point. I didn't, forgive me. When I said you want to hope that you get to refuse a notarization sometime, I want you to take that in the right spirit, of course. And this is why when both Susie and Kathleen said start the journal entry early, I mean early. As soon as you hear that somebody say, hello there, I'd like to have my signature notarized. I always say to them, I'll be happy to do that if you will help me to complete my journal entry, which we're going to start right this minute. And so the very first thing I get is the name and address and signature of that person in my journal from the beginning. Because I'm here to tell you, if a couple of minutes later I say, sorry, I cannot notarize for you today, I have to refuse, they're not going to be as cooperative at that point. You may not get the name, you may not get the address, you ain't going to get the signature because they're on their way out at that point. So I start early and I get that stuff in my journal entry first, especially in case I have to refuse. Now, what I was coming back to is this. Of course, I do not want any of you in this room to refuse the next person who comes in just so that you can have a refusal in your journal. Of course, I'm not saying that. If it happens, though, don't be unhappy, disappointed, worried. Like I say, you've just won the notary lottery. If you get, for legitimate reasons, to refuse to notarize for somebody. So do it.
Do you have to document in there, or should you document why you...
Yes, the lady is asking me, and I should have said that. Sorry, I should have said that. Of course, when you refuse, you put the reasons in the journal. Put the reasons in there for refusing to do so. And that should be followed up with the comment that if you do that, you've got to have a reason, an objective reason that you can articulate. It's not that, oh, I just felt uncomfortable, you know, I had a gut feeling. That's not what we're talking about. There should be one or more objective facts that you can point to. The ID print doesn't match up. Some is in one font, or the signature doesn't match, or the signer did not know who was president when I asked it. When I assess the willingness and mental capacity of people to be there, I'm very upfront with people. I say to them, part of my job is to make sure that you're mentally competent and willing to sign. So I'm going to ask you some questions that may seem silly, but we're going to do them so that I know that you're grounded in reality and so on. And so I say, what is today's date? Where are you today? Who is president today? What kind of document are we notarizing? I ask a few of those real quickly, and they ought to be that quick. I get the right answers, and I go on. If I didn't get the right answer, we wouldn't be doing any more of that notarization, and I'd put that objectively, did not know the president, did not know the date, and so on, so that I could have something to base my refusal upon that would be objective. Yes?
If we refused one in the past but didn't journalize it, is it okay to go back and mark it down?
The good question, since I've focused on this, the lady is asking, what if I got to refuse but I didn't journalize it back then? No, don't go back and do that. The journal, just like the certificate of notarization, is to be done contemporaneously with the notarial ceremony. And so if you miss that opportunity, you could make a note of it somewhere. Put it on a piece of paper, tuck it away, just so that you could say it, that you did it before you heard Professor Closen's wonderful lecture explaining to do this. So do that, but don't make a journal entry. Journal entry should be, right, ladies, Kathleen and Susie, I wouldn't go back and try to do a journal at that point. Make a note. This is why certificates, notarial certificates, shouldn't be prepared ahead of time. You don't put in dates, and you don't put your seal and your stamp and sign it and all that, because the certificate and the journal entry are to be done at the time of the notarial act during the notarial ceremony. And by the way, you don't fill that stuff out after, you know, if that signer's in a big hurry. Oh, I got to get going. And you say, okay, sign here. I'll fill those things out after you've left. No, 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 no. The document signer should have a right to know that you've done those things, that you've done them correctly. So do them during the notarial ceremony, not before, not afterward. I think that I've told you. Yes, we can go on to my second subject for just a couple of minutes here. How much time do I have left? 10? Yeah. About the unauthorized practice of law for just a few minutes, and I promise I will stop, but I'm going to tell you the couple of most important things. And the outline on this is pretty complete. You can read the detail for yourself. And the reason I'm giving less attention to this is that notaries worry a lot about this, but they're worrying too much about this. It is the rarest occasion, almost unheard of. Isn't it, Brianna, that you get complaints, and Sarah's here too. Do you get many complaints that notaries are engaged in the unauthorized practice of law?
Some, but statistically, it doesn't make up a very large portion.
Yeah. It really doesn't happen too often at all. Probably the more frequent time that you get concerns is when notaries who are Hispanic and use notario or notario publico, or foreign-speaking notaries who put their advertising in foreign languages, when they advertise that way. You probably get more unauthorized practice issues. Let me tell you a couple of the most important matters. And I've got a whole chapter. Chapter 26 in this book is about this. As a matter of fact, there are 30 chapters in this book, and I've got a chapter on almost everything, but it's chapter 26 in this book is about unauthorized practice of law by notaries. The idea here is that notaries who are not lawyers, and by the way, these laws are on the books all over the United States because of lawyers. They don't want people encroaching on them, right? I admit that. I'm embarrassed by that. I never wanted to be a real lawyer. That's why I was a law school professor for all these years. Lawyers wanted to protect their turf. They don't want other people practicing law. But there are some sound reasons for that, such as people who are not lawyers haven't gone to law school. Presumably, lawyers have learned more. People who haven't gone to law school and gotten a license, they're not governed by the lawyer's ethics rules and the court rules. They're there to protect legal clients. There are some sound reasons, of course, that non-lawyers, all non-lawyers, including notaries, should not be engaged in the unauthorized practice of law. Notaries, though, worry about it a lot because we deal with a lot of law-related, legal-type documents all the time. I should advance this. What constitutes the unauthorized practice of law? It is, I wanted to show you at least that you've got statutes, it's number 4, 3, no, where is it? This is, oh, there it is. I'm sorry, I had the wrong number. Point number 5, there it is from your Texas statute. It says it. It's against the law is one very important reason that notaries in particular should not be engaged in the practice of law. The most common place that a notary could get hung up is in providing this one, number 3, providing legal advice, consultation, opinion, or preparation of legal documents, with or without fee, by the way. Even when you volunteer information and aren't being paid for doing so, even free legal advice is the unauthorized practice of law. Notaries can get drawn in. Because you're dealing with legal documents, the document signer will fairly innocently say, "You think it's a good idea for me to sign that? What does that exculpatory clause mean over there? Do I need a witness for this?" They ask these questions of us as notaries, thinking we're notaries, we must know everything, including everything legal. Resist that. Don't do that, because that can constitute the unauthorized practice of law. In most of the rest of the world, in almost every other country of the world, notaries are also lawyers. In Japan, in the Hispanic countries, in Great Britain, if you're a notary, it's 99.9% sure that you're also a lawyer. That's just the way the system works. They do, thank you, they do law-related things. Notarization is something different in those countries than here. And that's why people with heritage from other countries, especially Hispanic countries, think that notaries are also lawyers. And we've got to avoid tempting them with that thinking. Kathleen has already suggested don't select the type of notarial certificate. In Texas, your Secretary of State helps you a great deal here. When you become a notary, they send you the sample forms. You are now protected, because if somebody comes in without a certificate or without notarial language, you can say, here, pick one. I'm not going to do it, pick one. They either pick one, or if they're unwilling to do it, you say, well, maybe you ought to consult a lawyer or talk to somebody else or talk to the party who's going to receive the document, but you don't do it. You've got the form to show them, pick one, and you're not engaged in the practice of law by doing that. So they've been very helpful. Notaries among you who are professionals in law-related fields are probably at greatest jeopardy by being pulled into this. If you're a banker, a mortgage broker, a healthcare professional, an accountant, a paralegal, since you're wearing two hats, you're a notary and you're one of these folks, there is a greater temptation, because you know a lot of law. By being in those fields, there is a temptation to do things that might look and sound like the practice of law. And that should be resisted. The other thing, I'm here to suggest this. It isn't required under Texas law. But if I were a professional, if I'm a lawyer, a paralegal, an accountant, or anybody, and a document that I've worked on, I've drafted, I've reviewed it, I've had any dealings with it, if that needs to be notarized, I am not going to notarize it. That seems like a fairly obvious, to me at least, a fairly obvious conflict of interest. If I've reviewed, prepared, completed, advised somebody on this document, and it needs to be notarized, if I then serve as notary, I'm biased. I'm not impartial. I want that to be notarized. And especially if I'm getting paid a fee for my consultation, preparation, etc., that fee was a whole lot bigger than the $6 for notarizing, right? So I'm more interested in that fee than maybe doing my notarial activities. I'd stay away from doing that. That's just an aside from me without having asked them about it. Now, quickly then at the very end, steps to take to avoid the unauthorized practice of law. Watch your advertising. You can read about it there. Don't mislead anybody. Advise clients, if you're going to have a poster or a fee schedule, put a line on there. I am not a licensed attorney in the state of Texas. And you put them on notice that you aren't. I'd post a fee schedule, and the fees you're charging are going to be a whole lot less than lawyers charge for their advice. So one advantage of posting a fee schedule and charging it and giving a receipt and putting it in your journal is that you ain't going to be charging nearly what a lawyer would charge for legal advice and consultation. Do not fully read the documents that are brought to you. If you don't read them, you can't answer questions about them. And resist questions. If somebody says, does this need a witness? I'm sorry, I cannot answer questions of that sort. What does that exculpatory clause mean? I'm sorry, I'm not permitted to answer questions of that sort. If you feel uncomfortable continuing, Perhaps you should consult an attorney and come back. I'll be happy to do your notarization then. Resist answering questions, because unless you start volunteering and throwing out legal advice, the only source of that problem is going to come from the signer in the form of questions. Oh, what should I do? Should I sign this document or not? So resist answering questions.
Sorry to interrupt. Just about out of time.
Right. Let me say one last thing, I promise. Here, number 11, do that. In your journal entry, state the time the ceremony started and the time it ended. You know why? That's going to be real short. What lawyer has ever said anything in the 2 to 4 minutes that it's going to take for the notarial ceremony? If that's legal practice and legal advice and legal consultation, it sure as hell is some of the shortest legal practice in the history of the world. So if you put that in your journal, you will have been protected also, right? I'm sorry, I always run over. She's used to me running over. Thanks for having me.
Thank you, Michael. Thank you. Sorry to interrupt.
Yeah.